So, dear colleagues, dear members of the public, dear candidates, advisory group of experts in its full composition is continuing with interviews with candidates for the position of Judge of the Constitutional Court of Ukraine. Our next candidate who is with us is Madam Karamaza Oleksandra Oleksandrivna, member of the Central Election Commission, who has been allowed to participate in the competitive selection by the Verkhovna Rada of Ukraine. The interview will be moderated by the secretary of the advisory group of experts, Mr. Yaroslav Romaniuk, and that's why I'm giving him the floor to moderate that interview. Please, Yaroslav.
Дякую, пане голово.
Thank you, Mr. Chair. Greetings, Oleksandra Oleksandrivna, and I greet everyone who's watching us. Zalar, who participates in their interview remotely, online. Physically present are Hanna Sukotska, Ms. Marina Connor, Ms. Natalia Kuznetsova, and Ms. Oksana Vasilchenko. Also, the AGE deputy members are also in attendance, namely Thomas Griffith, Richard Barrett, Marek Zubik, Vasil Shakun, and Volodymyr Kuzmenko. And also me, AGE Secretary Yaroslav Romaniuk. Oleksandra Oleksandrivna, we had time and we managed to collect sufficient quantity of materials about your candidacy, and we managed to find a lot of positive information. We also want to thank you for having communicated with the AGE, answering our questions, and you helped us create the integral picture about your candidacy. But altogether, the methodology defines the mandatory stage, the interview, and the aim of this interview is to give you the chance to clarify certain questions that are still not clear, and to give you the chance to debunk the doubts regarding your high moral qualities that are required for the position of the Judge of the Constitutional Court of Ukraine. I should also inform you that today we are not going to consider the information, documents, or other materials that you provide during the interview, and the information that we have requested earlier and you didn't provide within the time specified, but you're ready to provide it now. We can make an exception if it determines that such an exception is justified. I also would like to inform you that the interview is being recorded and streamed live on the AGE resources as well as the CCU website. Therefore, I call upon the AGE members and the candidate to limit the use of sensitive data and limited access to information on live air. And then if the situation requires, we can stop the stream and to have the conversation inside of the rooms of this room. As for the duration of the interview, it will approximately take 1 hour. And please respond to your questions in brief, laconic, in 3 minutes. Among members of the advisory group of experts, there are members who do not speak Ukrainian. They are English-speaking experts. So if your level of English, if you're not fluent in English, then you can use the headset that you see on the table near you, and the headset will give you the chance to hear the simultaneous interpretation into Ukrainian. If you need, you can use it. And before we wrap up the interview, you will have 5 minutes to do your concluding remarks. So if everything is clear, then we are ready to begin the interview. And the rapporteurs will be the Mr. Alois Zalar and Natalia Kuznetsova. So please, rapporteurs, the floor is yours. Thank you, Mr. Secretary. So I shall start. Oleksandra Oleksandrovna, I would like to start my questions concerning the purchase of the car in 2020. As we found out, on December the 9th, 2020, you became the owner of a BMW car model X5 manufactured in 2015 worth 149,000 hryvnias. Did you submit a notification of significant changes in your property status in connection with the purchase of this car? If not, please indicate the reasons for such non-submission. Thank you. Good day, dear members of the advisory group of experts, deputies, and dear Ukrainians. Thank you so much, Natalia Semenivna, for your question. Indeed, in 2020, I purchased the car with 149,000. Altogether, you stated correctly that I did not submit a notification of significant changes in my property status, since at that period of time, it was on December the 9th, 2020, and the norms of the decision of Constitutional Court as of October the 27th, 2020 were valid. And so October, November, and December until December the 30th, 2020, and based on the decision of the CCU number 13, that were recognized unconstitutional. And on the following day, on October 28th, the National Agency on Combating Corruption, they closed the access to certain registers, and all objects that were supposed to declare their changes in property status we were deprived. Well, I mean, all those who had this obligation, they could not do this. And this lasted until the 30th of December 2020, until the Verkhovna Rada of Ukraine made amendments to Article 52 of the Law of Ukraine on combating corruption. And okay, I see.
It is clear, so that in that period there was no mandatory legislation about to declare it. Can you tell how exactly were the payments for the purchase of this car made? By cash? By cash? So it was fully extant, was paid by cash? No, these were made by installments. But all this sum, like 149,000, were paid by cash in installments. Yes. But you are a validated doctor of juridical sciences with the civil law, international law dissertation. So you understand that this is violation of the installed order of operations? No. Look, this is the seller. I haven't violated anything. You mean that we had to do it through the bank transfer? 50,000 by 50,000. At that period, I had enough funds, and I worked in Central Election Commission, so I had on my account these funds. But the seller... So the initiative was of the seller. Okay, yes. Can you explain the history of the car's origin, in particular the number of previous owners, the main way the previous owners used the car, whether the car was involved in an accident before you purchased it? Unfortunately, I don't know the complete history of the car's origin, because I am not the first owner. The car was bought and purchased in Ukraine from the individual entrepreneur, and not even I don't know who were the previous owners. And about traffic accidents, I'm not aware. So a person who wants to purchase a car, not from the salon, this person wants to know what is the history of the car's origin. No, I was not interested. According to the official exchange rate to the National Bank of Ukraine as of December in 2020, the sum amounted $5,305. At the same time, according to the website with archived advertisements for the sale of the used vehicles, in that period from 2017 to 2019, a BMW car model X5 manufactured in 2015 cost from $32,900 to $33,600. For example, your daughter uses a BMW car model X3 manufactured in 2019 with a declared value of 620,000 hryvnias. Explain the significantly understated market value of the car you purchased in December 2020. Thank you. So, my daughter lives by herself. She lives separately, so we mentioned it just for comparison, like X5 is the higher model, and we see the discrepancy in the cost, in the value of cars, and that's why we ask you about it. Yes, I understand. For the first sight, I would say that this is a ridiculous price, but together with it, this price is a real one. It was installed by the person who sold it, and it was relevant as for the state of the car. And after, when I decided to repair this car, then I was said that it was really a bad decision to buy such a car, because it should have been repaired a lot. So I think you can agree that this price is very low for this automobile. But I understood that I should also import some funds for repair of the car. Tell us, please, do you possess any technical knowledge? No. And neither me. When I need to know the story or to know something like this, I address the specialist. For example, like I'm addressed as a lawyer, and it's very strange for me that you are quite a serious person with a serious experience, and you just bought this car because it is cheap one. So maybe you should have been interested in what you were buying. You said that you also paid serious funds for repair of this car, and you say that the repair of the car cost a lot, like 618,000 Ukrainian hryvnias, but you don't have documents that can approve this, that can confirm this fact. And when these repair works are done, then we have a question about the guarantee. For example, how much time this car can serve, or for example, if there are something that some repairs that hadn't been done, and then you find them out and they should be continued. So how often you make such substantial purchases without having documents? I would say that I belong to the category of people who collects all the documents and all the payment instructions when there is guarantee repair. So even working in Central Election Commission, all the secretariat staff knows that I am very serious about documents. And well, I haven't had them. Okay, next question. During the written rounds of questions, you were not able to provide the advisory group of experts with any explanation about the history of this car, photos of the car, documents confirming its repair during 2000 for as much as 618,000. Any payments for servicing and maintenance and parts provided. So how do you think, in your opinion, from the perspective of the impartial observer, does this not suggest a deliberate omission to retain documentary evidence of the market value of the acquired car, or perhaps negligence in safeguarding essential documents? So if we talk just about impartial observer, third party, how this party will perceive this information? Well, I would say the following, that I have never thought that safeguarding the documents can contribute and influence the integrity of the person. The same with the saving of documents on repairs. If each person preserved the documents about different repairs, these people would have quite a big library with all these documents. But it's not about it. We are talking about correspondence, the lifestyle and expenditures that person has, given the fact that this person has public functions and duties. When we talk about a person who nominates his or her candidacy for the position of judge of the Constitutional Court, the second thing is that people like we are observed from the point of view and perspective of society, and perception of the behavior, lifestyle, confirmation of the sources of origin of funds for acquisition of different ownership. So these are criteria for evaluation from the side of society of the status of the candidate. So that's why I explained you. I understand that the person, the shop assistant in grocery store doesn't safeguards and saves all these documents. But when we talk about the person who works in Central Electoral Commission, or a person who nominates his or her candidacy for such a position, such person is open to society. Okay, so let's pass to the next question about a house and a land plot in the village of Hnidin. On August 29, 2018, you gifted your daughter a land plot and a house in the village of Hnidin. This is Borispil Rayon, Kyiv Oblast, with a total area 256.3 square meters. So you owned this plot and house since 1997 and 1995 respectively. Explain how you acquired ownership of these properties, the land plot and the house. Thank you for your question. I will start from the land plot. I acquired the land plot in 1997. I was a teacher of elementary school. I lived in the village of Hnidin. I wrote a statement to local authorities, and I was given this land plot with the area 0.24 acres, and I implemented my right and I documented it as private property. As for the house was built on this land plot. We built it together with my husband, and in 1995 I acquired the right of ownership due to the settlement agreement. Okay. Did you carry out significant major repairs and construction works on the land plot or house before 2018? Thank you for your question. It is clear that since 1995 till 2018, this is a long period of time, and the house needed some minor repairs, for example, the substitution of windows. So stage by stage, we changed the windows, like the old ones to the plastic ones. But if we talk about significant repairs, major repairs, when we just build something else, when we change the area of the house, when we change the... So it's like a capital repair. Also, no, we haven't done it. Tell us, please. Explain the reasons for gifting this property to your daughter in 2018. Thank you for your question. Yes, to clarify all the doubts, because I understand that it looks like strange that I possessed this house and then I decided to present it as a gift. As my husband died in 1995 and my daughter remained semi-orphan, in the period after his death, I made myself a promise to present it as a wedding gift in memory of my spouse. Yes, don't worry, it's okay. Just take some water. We have a very gentle, very pleasant atmosphere. We just are talking about the conditions that can clarify all the doubts that can potentially arise during studying of the documents. So this is quite an ordinary process with learning about some actual conditions and circumstances. Okay, the next question. According to the independent valuation report you provided on August 17, 2018, so we understand that if there is no sale purchase agreement, if we have this gift agreement, so the law states that there should be done the independent valuation report. So the house was appraised at a market value 247,700 hryvnias. Translated to the NBU exchange rate on the day of the property transfer to your daughter on the August 29, 2018, this would amount to only $8,830 US. When combined it with the value of the land plot, we will have $28,700. Presently, comparable houses in the village of Hnidin, even with smaller square footage, are being sold for at least $140,000–150,000. How do you justify the considerable under-evaluation of the house during the donation process on August 29, 2018? Thank you for your question. Yes, when we settle and when we stipulate the donation process, the independent valuation report should be done, and as I didn't have any background and it was my first case with the donation agreement, so I had no experience and I didn't know which price should be stated. So that's why I addressed the independent valuation object, and this body provided me with this independent valuation report. But as far as I know, it is done only for taxation. As I had zero tax, it didn't contribute. So I didn't have any doubts in valuation of this property, as I'm not a specialist in valuation processes. That's why the valuation was done on my decision, so it is logical that I didn't have any wish to undervaluate or overvaluate its price. Okay. Let's talk about this independent valuation report. According to it, dated August 17, 2018, similar premises in Borodyanka Rayon of Kyiv Oblast were selected as analogs for comparison, with the square 65 square meters worth 190,000 hryvnias, with the area 72.4 square meters worth 180,000 hryvnias, 40 square meters worth 140,000 hryvnias, At the same time, the total area of the house you owned at that time was 256 square meters, and it was located not in Borodyanka rayon of Kiev Oblast, but in the Boryspil rayon of Kiev Oblast. So this is another territory, and the report doesn't mention any buildings on the land plot, nor does it mention the 8 living rooms in the house. Do you think it is fair to choose such analogs to determine the probable market value of your residential building at the same time, and not to take into account the important information as just described? And you said that it didn't contribute to necessity of taxation, etc. But when it is written in the valuation report, it should create any doubts why it is done like this. If we talk about the independent valuation expert report, like we are lawyers, if the analogs are searched, whether such different areas can be taken into consideration for comparison. So didn't you have any wish to ask the experts why it was done like this? So, did it make you worry? You know, I trusted the company with a certificate provided by the state fund of ownership. So, as an experienced specialist, you didn't have any doubts about justification of such an assessment of the value of the house. And given these circumstances and the fact that the normative monetary value of the land plot associated with it more than twice as high as assessed market value of the residential building, like terrain plot was 554,922 hryvnias, and residential buildings I have already said to you. And should your refusal to provide to the advisory group of experts with any photographs of the house and land plot that had been in your possession for more than 20 years be treated as questionable for the perspective as an impartial observer? So why you refuse to provide the photos? You know, I attribute myself to the category of people, of citizens of Ukraine, and for me it is strange to make photos of administrative buildings, of housing. Well, I haven't had such photos. Yes, so you think that there was no need?
Then I have the following question. Do you agree that the value of a household property is also affected by the buildings located on the land plot associated with such a house? Well, household property is evaluated in general, yes, but apart from household property, there can be some tennis court, for example, or sauna separately, right? So it can be the buildings that do not refer to the residential building, but, they can increase the consumption possibility or capacity of this entire complex, right? Right. So did you build a swimming pool near this house in Hnidin village? No. I do not have a swimming pool. My land plot, I have a land plot, and next to me is my sister's land plot, and there is no boundaries between the two. Okay, so we have the data from Google Maps. So land plot is looks like, okay, the experts have, I can draw you, give Oleksandra, and let's look at it. Perhaps Madam Oleksandra can show in this photograph the limits or the boundaries. I can, we have it. So this is my land plot and this is my sister's land plot. What does your sister have? What is the general total area of this land plot? I don't know. And what buildings are on the land plot of your sister? And how did she purchase it? because we have to understand. We understand that you have one land plot. Well, I have my land plot. She has her land plot. But did you show the line? Yes, here it is. And in maps, if you take a look at maps in the cadastre, okay, they go in parallel. Okay, we're just clarifying. Well, these lines, they are in the State Act for the right for the land plot. And then they do have these limits. I have provided it. Okay, I'll say clear. So you have explained that your land plot borders with your sister's land plot, and the swimming pool is on the sister's land plot, and she was building it, right? Constructing it. And what other buildings are there on your sister's land plot? Does she have a house? Yes, she has a house. It's the house that next to... No. Here she has her house. That's her house. Well, she has Luhova. So you do not have any line. No. That's the problem about this. My daughter is working on this issue and want to make the boundaries. Okay, let's switch to another question that's not connected to the property, but it refers to your political status and so on. At the parliamentary elections in 2019, you participated in the elections, and you participated in elections from the Servant of the People Party, right? What is your... are you a member of this party? No. I have never been the member of this party. So what political relations do you have with the party of the Servant of the People Party if they have made you the candidate for the MP? I was appointed by based on the list of the Servant of the People Party, but I want to explain how I got there to debunk the doubts. Yes, please. If I'm not mistaken, it was May. I read in the mass media that they were enrolling the citizens of Ukraine that are in line with the electoral census, and they wanted to realize my constitutional right. It wasn't even on Facebook. I think it was on the internet, just in general. And I called them. I introduced myself, but I never say that I'm a civil servant. I always say that I'm a teacher. And at that moment of time, what position did you have? I was the chief specialist in the legal department of the Baratus of Verkhovna Rada, but also like a civil servant. So I called them, I introduced myself and told them that I was willing and I was in line, that I was eligible. And then they called me back, and I got number 162. Did you pass? No. I did not pass, but I see Oleksandra, Natalia Alexandrovna. So, and then on October the 4th, 2019, you were appointed as a member of the Central Election Commission. How can you explain the potential connection between your participation in the elections from the Servant of the People Party and your appointment as a member of the Central Election Commission after the victory of this political party? Did you do something? Did you show yourself in this pre-electoral campaign? How did you become the member of the Election Commission? Thank you for your question. I would like to debunk the doubt here, so that there are no more speculations, as this is a very sensitive topic for me and for the society. And here I should say, I did not take any political actions in the electoral process. I was just part of the list under number 162. Then I wrote the application refusing. And if you take a look how I became the member of the Central Election Commission, then you have to pay attention that the members of this commission are appointed by the Verkhovna Rada on the application of the President of Ukraine, because Article 3 of the law on the Central Executive Commission says that independence of the members of the Central Executive Commission can be guaranteed by the specific order for appointment of the Central Election Commission members. So there was the application by the President for my assigning, and there was the resolution, and then the Verkhovna Rada voted it. Okay, I see. One more question in relation to these conditions. Your mother, as of 1992 to 2015, participated in multiple elections, and the last one on behalf of Radical Party of Oleg Leshko. And she is linked to a company associated with MP Serhiy Taruta, who serves on the Verkhovna Rada committee, where your daughter has been employed since 2021. Do you think that all these facts, in opinion of the objective observer, could be regarded as doubtful or compromising your independence and impartiality? Let me start by saying, well, first, my sister, I don't know where my sister works. We're not close with my sister, and due to, I mean, it's personal. I don't know where she works, and if your data is true, I cannot either confirm, nor confirm, neither reject this information. My daughter works in the committee where this MP is. Well, I don't know. I don't have this information, and I don't know this MP. And I think that no links here. I see. And regarding such, tight contacts with different political parties and participation in the electoral process, do you think this may affect your impartiality, independence? Can this pose doubts in the CSOs? They're following this very carefully on Facebook and other social media. Let me explain. I am the member of the Central Election Commission for 4 years now. If the Society of Ukraine had any facts that I had committed any actions indicating the number of events that you have just named, Natalia Semanin, I think the society would respond to it, because our society is very sensitive about these things. And in my work, I am loyal to the oath I took to the Ukrainian nation to be not to belong to any party, and my position in the Central Election Commission is the proof of that. And the fact that my mother has her own political life, well, she lives separately from me, and I even heard for the first time some of the information that I didn't know about them, because of my work, I do not monitor life of my mother or life of anybody where she has been. Okay, I see. We understand your position. Okay, let's my last question for you regarding your scientist activity. As a scientist, you do understand that there are certain standards that us scientists cannot violate. And when you have conducted your dissertation, study, and so on, so a comparison of the texts of your article, the title, "The Concept and the Content of Civil Legal Proceedings," published in the Scientific and Information Bulletin of the Ivano-Frankivsk University of Law, named after King Danilo Halitsky. And your article, the title, "The Theory of the Civil Proceedings and Its Importance in the Context of Protecting and Safeguarding Citizens' Rights in Ukraine," published in the Kiev University of Law Journal, shows that the texts of these articles are almost identical with certain modifications. The article published in 2017 does not contain the reference to article published in 2016. Qualifying this from the point of view of the current legislation on academic integrity, this is the fact of the safe plagiarism. So why did you publish your 2016 article with minor modifications republish? Why did you republish your article in 2017 but with minor modifications and under a different title? What is your attitude to the rules of the academic integrity? And I want to show you. It's basically the same article. That's a possible phenomenon, of course. I mean, it's possible you can reprint it or republish it. Maybe first article, it was published in some unknown journal and you wanted to make it more popular, but then you have to say it that this article was published in the following journal and so on. And this way, the observer will understand that you're working on this topic and basically you have republished the first article. That's why in the legislation we have such a violation of norm of academic integrity as safe plagiarism. So what can you say on account of this? That you did not link article in the Kiev University of Law to the University of Law named after King Danilo Halitsky. When the article that was published in 2016, so the title, maybe vice versa, well, it doesn't matter. So the article in 2017, I'm answering. In 2017, I did publish this article. At the same time, I would like to draw your attention to the fact that at that time, my article was in line with all requirements of the first journal and the second journal for such articles. Why? Because back then, no self-plagiarism notion existed. It appeared at the end of 2017. And the law has no reverse action. But altogether, I'm not saying that. So, I mean, if we talk about this today without considering, we're all lawyers, we understand that the law has no reverse effect. And articles that were published before September 2017, from the legal point of view, cannot be considered as self-plagiarism. But altogether, I should say that the legislation did not define self-plagiarism. No legal act had its definition. Maybe I'm mistaken. You probably have more experience. Okay, I will share my experience with you. But can I still add? Okay, sorry, I need to finish. But this was indeed the continuation of the previous article. But if I'm not mistaken, the journal, I did not have the paper form. That journal, they didn't send it via email. They would call, and it was near the university, and we would go and pick up the journal. And at that time, when I have submitted this article, I mean, I am, of course, responsible for this, and I don't want to avoid this responsibility, but it's just that it was not prohibited. But as for the moral, ethical norms, I suppose it's reasonable, but not banned by the legislation. As for today's current opinions of mine about this, You know, I have thought about this. Since I have a lot of experience in the draft law experience, I wanted to go to the subject of the legislative initiative. But you see, I'm not the only one who got into the situation like this, and maybe I should follow another track. Okay, let's not speak about the possible ways of quitting or, tackling this. The thing is, irrelevantly from whether or not in the law this term was identified back then, but in 2009, according to the clauses that were shaped by the scientific community, it was envisaged that the scientist should not repeat his or her scientific publications in order to increase their number. That's number one. Second, you did defend your dissertation, right? Your doctorate thesis. So I guess you were familiar with the requirements for the publications of articles, scientific articles, which from time to time were prepared by the higher attestation collegium, long before the notion of self-plagiarism appeared. And there they said that you cannot publish the same article under different titles in order to have more articles. That was part of the agenda. So it seems to me that even in that period of time, that was like a negative phenomenon when the same scientific product was multiplied by just submitting the same article but under different titles at the same time to different journals. Like you just said, that you don't know where it was issued, right? Where it was published. But yeah. Well, now you will know. Now you will know and understand that it has been normed and it is negatively perceived both by the CSO and the scientific community. I have no more questions. Mr. Oleksandra, please.
Yes, thank you. I will continue with some questions, Madam Karamaza. First of all, I would like you to clarify the sources of funds for the purchase of a car which was purchased by your daughter on February 10th, 2017. She purchased a Peugeot car, model 308, manufactured in 2012 for 232,000 Ukrainian hryvnias. As you explained, the sources of funds for the purchase of this car were your daughter's personal funds received as salaries during the period from 2014 to February 2017, as well as funds provided to her by her grandfather during his lifetime in the amount of $2,000 and in the amount of 62,000 Ukrainian hryvnias. Now, according to your daughter's income statements for 2014, 15, 16, we received a total of just over 141,000 Ukrainian hryvnias in income after tax. So, if we add this amount to the savings you described, we will get a little more than altogether 257,000 Ukrainian hryvnias. And if we deduct the cost of the car, it turns out that from 2014 to January 2017, your daughter spent only 25,000 hryvnias on her daily needs, which means that during this period she spent 700 Ukrainian hryvnias per month for her daily needs, which is, of course, much less than the subsistence levels amounting to 1,100 hryvnias in 2014 and 15, and 1,300 hryvnias in 2016. So there is a gap, and we want to clarify how you see this situation. Could you explain this?
Дякую.
Thank you. Yes, my daughter purchased a car. Peugeot car, I don't remember when it was. It seems 2017. For the funds, she saved. Like it was purposeful saving. As for her daily needs, she had she was partially paid reimbursement from the university, and she lived with me. So it was and it was enough for us.
In your written explanations, you have confirmed that in 2021, your mother purchased a Honda car, model CR-V, manufactured in 2021. What is the cost of purchasing this car? What sources of funds were used to purchase it?
Thank you. Yes, my mother is not a member of my family. About the law on corruption prevention, that's why I don't declare her. I know that she purchased such a car, but I am not aware, but I have never used it. And if you ask about the color, I don't remember what is the color. I know that there is a dark one. About the sources of funds, she said that these are legal sources of funds, but together with it, she rejected to provide me information. She said that, and I respect her constitutional law not to interfere in her personal life. She said that all the sums, all the funds for taxation she paid, and she in written form refused to provide me such an information.
What kind of relationships are you with your mother? Are you okay, you two, or it's a rather cold relationship?
Ні.
No, these are good relationship like mother and a daughter, family relations.
But this is rather strange that your mother doesn't want to support your candidacy for the judge of the Constitutional Court of Ukraine, since you have to prove the high level of moral quality, which of course to a certain extent relates also to the source of property, you and of course your close relatives. Okay, let's continue with this issue. Now, according to the data received by the advisory group of experts from NABU, the cost of this car, your mother's car, was 1,111,000 Ukrainian hryvnias. And according to the State Register of Individual Taxpayers from 1998 to 2021, your mother's pre-tax income amounted to 847,000 Ukrainian hryvnias. So you see, much less than was the value of the car. Now, how can you explain this situation? How can you explain this situation with respect to having enough funds for her to purchase the relevant car?
For me, this information is new, because really I don't know the sum, the cost. If you need me to present documents, well, she is not member of my family. I don't know her incomes. I can... Well, if she said that the incomes were legal from legal sources, I believe her. I have no other explanation. If it is needed, I will come to her again and I will ask some proofs and documents?
And let me just remind you, according to our information, your mother, since 2004, has been living in a house in the village of Midden. And this house was until 2018 owned by you. And therefore, your mother is related to your property. And the AG may take into account your mother's property when assessing the fulfillment of the criteria. But I just, this is just my remark to you that you understand why we are asking this. I have another question. According to anti-corruption legislation, your son-in-law is considered as a close person. According to the advisory group of experts methodology, the wealth of close persons may be considered if there are indications that it is related to the candidates or their family's income, property, or lifestyle. Now, while you declared your daughter as a family member in your electronic declarations until 2018 and gifted her your house and land plot in 2018, she has been declaring your son-in-law as a member of her family since 2018. And he has owned an apartment in Kiev with a total area of 127.5 square meters since August 24, 2012. In addition, he owned 2 parking spaces in Kiev since June 18, 2020, another parking space in Kiev since December 7, 2021, a BMW car model X3 manufactured in 2019 with a declared value of 620,000 Ukrainian hryvnias since January 12, 2021. Now, at the same time, each of your daughter's e-declarations contains no information about the income received by your son-in-law and his monetary assets. Moreover, your daughter's declaration for the reporting year 2018 states that your son-in-law refuses to disclose information about his financial assets. So not just your mother, also your son-in-law refuses this. Now, how do you see his position? Do you share your son-in-law argument? Because he says that that he refuses this based on the violation of constitutional principles such as the rule of law, prohibition of interference with privacy, and non-disclosure of confidential information, contrary to the European Convention on Human Rights. So do you agree with his opinion?
I would like to state that both my mother and my son-in-law, they do not live with myself. As most citizens of Ukraine, I respect the guarantees and constitutional rights foreseen by the Constitution of Ukraine. And to influence and to force them to provide me the necessary information, for me, will be violation of the constitutional norms. I will neglect the constitutional norms. I have my duty to investigate with all the reasonable ways and modes their incomes. But as far as I can investigate it, I do it. And I have never thought that if my mother and my son-in-law are guaranteed with the right of their constitutional rights and they follow the rights, I am not in grade to force them to do something they don't want to. And I have never thought that it can contribute to my integrity because they don't live with me. Yes, in understanding of the law on the corruption prevention, they are my close relatives, close persons. So I respect their rights. This is their right.
We just want to remind you that we must clarify any doubts with respect to your high moral quality issues. And according to your written explanations and now also oral, once your sister refused to disclose information, your mother refused to provide information on the legality of the sources of the funds for the purchase of her car in 2021, your daughter did not give your consent to photograph buildings on the land plot in the village of Niden. Your son-in-law refused to disclose any information. So do you understand that such activities or non-activities of your close relatives, close persons, raises reasonable doubts from the perspective of an objective observer as to the correspondence of their property status with their income?
I would like to state, responding to your question, that neither my son-in-law, nor my mother, nor my sister are subjects of declaration under the guidance of the law on corruption prevention. I respect all the rights of all the citizens, and there is evaluation definition of openness or not openness for disclosure of the information. As I believe, when you respect the rights of other person, you don't force this person to do something. Yes, you have to do something, you have to do all the possible actions, you have to pass the interview, but if they are not subject to declaration and if they reject to present you such information, then I think it cannot show integrity, my integrity, or lack of integrity, because it is their lives. These are their lives, these are their incomes, and I have no attitude to them. Okay, we understand. You understand.
Let me ask you the following question. In 2020, you published an article on mediation in election process of Ukraine prospects for development. This article was co-authored with Oleg Koretsky, managing partner of Koretsky and Partners law firm. Could you explain your personal or professional relationship with Mr. Oleg Koretsky?
Дякую.
Thank you. In the year 2000, there was an article about the mediation in the election process, and Oleg Goretsky was mediator. I was a person who deals with the problems and issues of the election process, and in the same period there was foundation of the university about digitalization and artificial intelligence, where he was the head, the chairman of the department, where I had intention to work. And as I am scientist and he's mediator, and it was really very interesting for me, and even today it is interesting for me to the knowledges of practice and mediators in the sphere of mediation. And we published together with him article. This is the only article. Then in the University of Digitalization and Artificial Intelligence, it was established in 2020, in the end, in December. And as I am not a lecturer of this university, and I created educational programs for this university, so these were only professional relationship with this person, because I was really very interested in his techniques.
I understand, thank you. My last question. In the fall 2021, you participated in a competition for selection of the candidates for the position of a judge of the Constitutional Court of Ukraine for persons appointed by the President of Ukraine. And you know that there was a lot of issues concerning the unconstitutionality of the revocation of the decrees appointing two justices for whose positions this competition was announced. The illegality of this decree was later confirmed by the Supreme Court. So I want to know why actually you participate in that competition. As a candidate for the position of a judge now, how do you assess your participation in such a process, taking into account the problematic issues which were finally confirmed by the Supreme Court?
Дякую.
Thank you. In 2021, I participated into the competition, and I would like to say that this election procedure contained the expert group with national and international experts. It was transparent procedure according to the legislation. Yeah, I understand. I should be more... Well, it's not about... Well, the order... Well, it's not about the claiming. The correspondence to the Constitution, so the firing of the previous judge of the Constitutional Court. So you understood whether his dismissal corresponded or not corresponded to the Constitution of Ukraine. That's why your motives of taking part into such a doubtful contest. So you couldn't fail to understand whether it corresponded or not corresponded. Well, Supreme Court didn't cancel the competition. The competition happened, and it wasn't under doubt. And there were issues with the dismissal of Tupitsky. And this is about another issue. If this competition hadn't been constitutional, if it had been held against international agreements, I don't think that international experts would have kept silence. So you think that it was under the stated legitimate order, and about the places that were there, it meant nothing for you. Well, then after it was recognized, but the competition, yes, it is clear. So ask, for you, was it important that you as a lawyer understand some doubts about legitimacy of the dismissal? So did you take into account that these people were dismissed without sufficient reasons? Or you didn't think about it? So this is the question. And the competition was held under the procedure, and it was...
Well, the competition was legitimate, and I applied for the legitimate competition. We understand your position. Are there any other questions for the candidate? If there are no more questions, then we are ready to wrap up the interview. But just like we mentioned in the beginning, now you're given the floor to do the concluding remarks. Thank you. Dear members of the advisory group of experts, deputies, dear Ukrainians, I'm speaking to you as the candidate for the position of the judge of the Constitutional Court of Ukraine. And my aim is a lot more than just to become the judge. I want to be the catalyzer of the changes in the judicial system, because today's competition, it's not about selection of new candidates. It's about changing the vector of development of the Constitutional Court. And allow me to express gratitude to our defenders, Ukrainian people, without whom this competition wouldn't be possible. I also want to express gratitude to you, dear experts and your deputies. As today's conversation was well grounded, it was very important to eliminate all doubts that exist on my candidacy. Because if you had questions or doubts, that anybody can have them, because that's just the society that we live in. And I also would like to sincerely thank you for being so attentive to questions and giving me the chance to answer these questions, to discard any doubts. So, dear experts, I should be honest with you. Your attention, it evokes different emotions. But as for me, it only evokes my respect for you. I respect your principality in the part of the integrity, your professionalism on the part of the selection of the judges of the Constitutional Court. And that's the kind of respect that I want to achieve working in this position. And if I have a chance and I manage to become the judge of the Constitutional Court, I want the respect that is based on serving the Ukrainian people, because we are serving Ukrainian people. And if I am selected as the judge of the Constitutional Court, I'm ready to be a non-compromising one, just like you are at this interview. Because, my reputation is something that I value the most, and it cannot be, lost and found. And Ukraine is now, of course, focused on the victory. The moment the hostilities are over, the Ukrainians will start returning to the peaceful life. And they will have a very acute feeling of justice. So I want to look in the eye of the defenders with brevity, and to the eyes of their children and grandchildren with confidence, and in the same way that I'm right now looking into your eyes, dear members of the advisory group of experts and their deputies. For me, this is important. What is important for me is openness and sincerity of the eyes. Not just like the candidate for the position of the judge of the Constitutional Court, but primarily as the citizen of Ukraine, because we all serve the Ukrainian people. And together with you, we are building up our wonderful Ukraine. So thank you so much. Glory to Ukraine. Thank you for your answers, dear Madam Candidate Oleksandra Karamaza. And now I announce the interview with Karamaza Oleksandra over.